Hello and welcome to Fraud in America. I'm Jackie Damar, and today we are joined by two guests that are going to talk us through AI. AI is everywhere, it's being used in everything, and I don't understand it at all. So these guys are going to talk about it at least a high level. I'm going to turn it over to Dave Jochnowitz to introduce himself and Rachel Rose right after that. They are both practitioners in whistleblower law and False Claims Act work. And they are going to talk a little bit about themselves first. So, Dave, you want to start?
Sure, happy to. Thanks for having me and Rachel here. It's great to be chatting with both of you about this. My name's Dave Jochnowitz. I'm a partner at Outten and Golden. I'm the co-chair of our whistleblower and retaliation practice group. We focus on representing all kinds of whistleblowers in both employment and False Claims Act, SEC, CFTC, other whistleblower claims. I've been doing this for a little over 10 years, and it's very exciting slash scary slash interesting slash every other word you can come up with to be practicing now as all of these new AI tools come into use, and we're all trying to figure out how to use them. So very excited to have that conversation today.
Absolutely. All right. Turn it over to Rachel.
Thank you, Jackie and Dave. Likewise, I'm delighted to be here and discuss this fun topic. I'm an attorney in Houston, Texas, and I've had my own firm for going on 15 years now. I also teach bioethics at Baylor College of Medicine. And in addition to doing False Claims Act and Dodd-Frank and other whistleblower program work, I also do a lot of transactional and compliance aspects of cybersecurity and healthcare. I've also been fortunate to write several articles and even publish book chapters and books on cybersecurity and artificial intelligence.
All right. So, at a high level, can you kind of explain the technology and what it does?
Okay, so I'll begin with our favorite lawyer answer, and that is it depends, Jackie. So, artificial intelligence in its base form is essentially a branch of computer science that relies upon an algorithm, and all AI relies upon an algorithm to basically synthesize data that's being put into it. And then, depending on the type of AI application, the output. So, what do we mean by the type of AI application? It can be something that we're all familiar with, a large language model, almost analogous to a Google search or a Westlaw search, where there's data and it really ranks the data in that way and then gives us an output based upon that. The most common item that Dave and I will be focusing on today is what's known as generative AI. And the difference between the more traditional AI and generative AI is that with generative AI, there's a component where a new item is being produced out of all the data that's being inputted. To say that AI can reason is a bit of a stretch, but even if one reads the NIST or the National Institute of Standards and Technology definition of generative AI, you'll see that term reasoning in there. And that's really the misnomer, because as Dave and I will delve into, that's where a lot of the landmines potentially are. Finally, there's agentic AI, and the most common example of that is a self-driving car. So that really is what AI is. It's model, and it relies upon an algorithm, which is essentially a mathematical
Dave,
formula.
did you have anything to add there?
Yeah, so I mean, nothing to add or supplement to all of that because I completely agree with all of that. I just did something kind of interesting in preparing for today. What I did was I took the AI system that we use, which is a closed system internally, and I asked it, what is the definition of AI? And it said The Oxford Dictionary defines AI as, quote, the theory and development of computer systems able to perform tasks normally requiring human intelligence, which sounds like a great answer. But actually, that's not what the Oxford Dictionary says. If you go to the Oxford Dictionary's website, the Oxford Dictionary actually defines it as the capacity of computers and other machines, blah, blah, blah. It's actually a completely different definition from the Oxford English Dictionary. Similar results. I asked it, what does the European Commission think? It gave me an answer that was not the same. I asked it, what are some other definitions? It said Stanford University says that artificial intelligence is the science and engineering of making intelligent machines. But just looking on Stanford's website, there are lots of different definitions of it. It's funny that the core challenge with AI, which is it reliable? And generative AI, is it reliable? It can be sort of boiled down in just asking it, what are you? And it's not even necessarily going to come at you with the correct answer. This isn't to say that I want all of this discussion to be negative or that AI always generates wrong answers. I just thought it was very, very funny that it started off just like that. But I think that in general, yeah, AI has there's a lot of different things that we bucket under AI, like the same way that we bucket under whistleblower. Whistleblower takes on a lot of different forms. Lawyer takes on a lot of different forms. Doctor takes on a different form. So I think Rachel's definitions are great.
So interesting and hilarious that it got the answer wrong when you asked it. That's amazing. But that's one of the problems we're going to be talking about in a little bit. Right. So, um, in a big picture context, how is this being, or is it being at all regulated? What are the implications for like cybersecurity concerns, things like that?
You raise a great question, Jackie, because in terms of regulation, not surprisingly, it's still in its infancy. And the first country to come out with a regulation is the European Union. Ironically, it was supposed to be Brazil, but they didn't quite get theirs across the finish line, and the EU beat them to it. But in all seriousness, the EU AI Act is really the preeminent law that governs AI. That became effective in August of 2024, and we're seeing the phased in implementation being introduced right now. So that's on its way. In terms of the United States, we're still more on the state by state basis, which isn't surprising, almost like what we've seen with a lot of the privacy laws. The states have come out first with different AI laws. And it's not only in relation to general utilization of AI, a lot of AI laws are coming out in the healthcare sector, and not surprisingly because of the safety issues that are surrounding AI. And one in particular is Texas Senate Bill 1188 that was signed into law in June 2025 and became effective September 1 of 2025 by for all components, with the exception of in Texas, beginning in January of 2026, all the data needs to be housed in the United States. So that's where the dovetailing in terms of an AI component, which in the Texas law requires that physicians meet their professional obligations as set forth by the medical board and other laws to ensure the accuracy of what's in the medical record, as well as when they're applying the signature that they have in fact read that information before they apply their signature. And then if we dovetail that, if we go to, like I said, where the data is supposed to be housed, depending on your algorithm, where is your data coming from? And if it is sensitive data, whether it's as an attorney, our attorney-client privilege data, or protected health information, or if someone is doing a whistleblower case or defending a case with bank routing numbers and bank account numbers and social security numbers? Are all of those being pulled into this algorithm? And what safeguards are in place? What if you have someone who just came into your firm who was with the government and they need to be walled off from a particular case or cases, and then AI's application has taken data from all these client files, even in a closed system, so that they could, in fact, potentially see something that they're not supposed to see. So, for AI to be effective, it needs to be secure and the confidentiality needs to be protected. And I'll delve into the blueprint for an AI Bill of Rights in a moment. But Dave,
I
do you
would
have
just say
anything
that
to
I
add?
think that there was very briefly an effort to centralize everything with the first draft or one some of the early drafts of the consolidated funding bill that the administration put forward. And, you know, I think there was a lot of pushback on that because so much of this technology is new and, you know, while AI, I think, has been around for a long time, I have a little bit more to say about that later. AI in some form has been around for a long time. The type of stuff that we're seeing now and the wide scale access to it is, I don't think you can reasonably say anything other than revolutionary. And so having a single set of rules that are the same across the country kind of gets rid of one of the core ideas of federalism and allows states to figure out what works and try different things. And maybe some of those things will foster amazing pieces of innovation, and there'll be lots of hands off approaches that allow that. And maybe there will be more restrictive approaches that protect consumers more. And maybe there will be places that find the right balance of those two things. And so allowing it to happen at the state level is really great. I think the challenge, of course, is that AI really is very hard to put into a, a I don't want to say made up, but a non-physical line on a map. It's very, very hard for that. And I mean, we know that it's possible to implement all sorts of restrictions, but the reality is that figuring out how to regulate this stuff, I think, is going to be really tricky. And the only other thing I would say is, we've always had programs go crazy. I am old enough to remember the year 2000. And so I am old enough to remember when everybody was freaking out about the fact that the the last two numbers and the date were going to be 00. And supposedly this was going to end the digital world. And all I could think of as a kid when that was happening was, why don't they just change it? Why don't they just make
Yeah.
that better? And that's what they did. But it was people really freaked out about it. This code and this information is so much more complicated and so much more complex to the point that people who work on it sometimes don't understand, and particularly at the beginning, they really didn't understand. So how are you going to put a one size fits all immediate approach to regulation? And how are you going to say completely hands off when we know that this stuff can be dangerous if used inappropriately? So I think the question of regulation is really important. And I think thankfully we're at a place where everybody agrees that there need to be guardrails in place. Most people agree that there need to be guardrails in place. And then now the question is, how do we figure that out? I think the White House blueprint um, is kind of like a good jumping off point for that because it's not super technical. It's more of a list of concepts that I think inform rather than necessarily strict rules.
Yeah. Yeah, and it's interesting. So that White House blueprint for an AI Bill of Rights that was under the Biden administration, and it's really protective of consumers, right? Like that it's more protective of people using it. And then jump to this year, Trump's has an AI action plan, which doesn't necessarily it it doesn't really take into account like those privacy issues. It's more how can we use this to innovate? And so, it really kind of it really focuses on accelerating innovation, building more infrastructure, and then trying to get our model kind of into the world. So, Rachel, did you say you were going to talk about the White House Bill of Rights?
Yeah, so there are 5 elements to that. And I use them and I advise my clients to use them because, as Dave suggested, they are a great framework. Because even though the executive orders or announcements that are coming out now are driving innovation, you still need to protect and adhere to other laws like HIPAA, like GLIBA, and other items if you're housing government data under the federal acquisition regulations. Do you have CUI and
Yes.
FCI? If so, you really need to have these
Can you
5
talk about
items
what
in
the
place, right?
situation is though first?
So,
Because you
do you
just
want
use acronyms that not everybody might understand.
Uh, yeah, so HIPAA is the Health Insurance Portability and Accountability Act of 1996. GLIBA is the Graham-Leach-Bliley Act, and that, as many people know in the financial sector, in some ways has similar provisions within it, like HIPAA to PHI, protected health information. It applies to sensitive, personally identifiable information and the financial transactions and how the financial data needs to be protected. We then have FAR, the Federal Acquisition Regulations, and the 15 basic cybersecurity safeguards are found at FAR 52.204 21. And so those really are important for not only cyber, but also AI and what we're about to delve into with the AI blueprint for a Bill of Rights. And then we have FCI as federal contracting information. And so federal contracting information is not always what the government generates. It can also be what a grantee or a contractor or grantor or subcontractor is getting to the government, right? If they're doing a type of study, well, that's not being generated by the government. That's that two-way street of transmitting that type of information. So the way those all come together with the blueprint is, first, number one is the information secure? Said in other ways, it's safe, legal, and effective. And do you have adequate te- technical, administrative, and physical safeguards around that application? Second is there a discriminatory impact? And this is very relevant in our world in the False Claims Act. And we've already seen the Department of Justice go after the company formerly known as Facebook, Meta, in terms of HUD violations, the Housing and Urban Development Agency violations, for having a discriminatory impact on advertising of certain properties that were available and limiting the groups that that ad went out to. So they were fined, and also they had to redo their algorithm. So this is not a small undertaking, and it's not an area that the government is necessarily turning a blind eye to. Number 3 in the blueprint is the data kept confidential? Number 4 is, are there adequate disclosures in place to inform people that you're utilizing AI? And in medicine, just like law, a human being is the only one who can hold a license, right? AI, an application, cannot be a licensed professional. And so, are there adequate disclosures surrounding that? And in medicine, it comes up with AI generated text messages. In law, it comes up in marketing scenarios with chatbots and everything else. So, these are real world applications. And then the last component, this is my favorite component, and it really underscores what Dave and I are going to be delving into with the legal landmines for practitioners. And that is, do you, I call it the trust but verify, do you have a human check factor on the output of what's being generated? Just like Dave went to the original source of the Oxford Dictionary, that was for a basic definition. And by doing that, he could have avoided a hallucination being put into a pleading, which could have been potentially costly in terms of sanctions or having an expert removed or having authentication objections raised. So there are really a lot of downstream issues that can be avoided if lawyers, if like I advise clients on this, we put this framework in the policies and procedures. And so that people can avoid
Yeah,
downstream
so let's talk
liability.
about that a little bit. How is it currently being used in like the legal and compliance world in practice?
I think, I'm much more familiar with how it's being used in the legal space because my firm is very interested in trying to figure out how to appropriately and ethically and effectively use this to be sort of like a force multiplier to allow us to remain lean, but then do more work on behalf of you know human beings. One thing that we've used is a program. Assume it's okay to name a few specific, just like examples. But one thing that we used was Eve, which it's an AI tool that allows you to very quickly draft pleadings. So when you have sort of a template that you follow, it's really, really good at generating those things, generating initial pleadings or initial demand letters, things where you do the same thing and it follows a very consistent structure. And it's good at pulling out information from a limited subset of documents. This is a closed system where you tell this is the only information you can have, this is the template you follow, and then you go through it. Now, what's really great about it is it avoids the challenge that a lot of lawyers face, which is how to get the first words on the page. And that's great, but then you do have to verify everything. You have to ultimately go through. You have to check every single citation. You have to make sure that every fact is in there. And there's always the challenging question, particularly in a practice like ours, where in the False Claims Act, you have to be meeting higher levels of higher pleading standards or more onerous pleading standards. Are you actually meeting those pleading standards? Are you missing key facts? Are you leaving something out that that really needs to be in there? But that's what Eve does. It gets rid of that first work. And I know a lot of law firms are using that. I think probably the most common way that firms have been using AI for a long time and are now using it in a Gen AI format is document review, because gone are the days of warehouses with paper in boxes. Thank goodness I managed to start my career after that. But the inundation, particularly in high stakes, large healthcare False Claims Act cases or securities law cases, the number of documents is just unreviewable by people. It cannot be done. And so you have to use technology solutions. And there have been various ways to do that, including like, TAR, technology assisted review. But now we're getting into the realm where um, AI is going beyond technology assisted review, and AI is being taught how to think about document review and how to actually go and find critical documents. But, as many people who practice in the space know, sometimes it comes down to one email. And so there's always the fear in the back of your mind that if you don't find that email using your AI tool, did your AI tool understand, in quotes, because it doesn't really understand, but did your AI tool, did the math and the coding behind it come up with the right thing to be looking for in all those documents? But that, I think, does have the potential to really reduce the costs of litigation. I think the reality is that having lots of human beings clicking buttons, looking at documents, highlighting them is really expensive. And there may not ultimately wind up being a way to avoid a substantial portion of that, particularly when you're talking about issues of privilege. When you're reviewing documents for production, you really don't want to have a mistake there, or when you're reviewing documents to make sure you're not disclosing PII, personally identifying information, highly sensitive information. But it is so expensive to do discovery, and these are real ways to cut it down. I think that those are some of the really big ways that my firm is using, and that I understand other firms are using AI in the legal
Yeah,
space. And one thing I would just add is that also you just like type into ChatGPT and get a faster answer than having to click on a link in Google. Um, yeah, but
yeah.
that's not specific.
I came in just, I guess, under the wire of still reviewing paper documents, not always, but some. And I remember as a first year associate, I was working on the weekend, of course, and I was reviewing boxes of paper documents that had been found in someone's garage, and I just, like, opened the first box, and there's a dead spider on top, and I was like, "I what am I doing? What are we doing?" So, I'm really
Yeah.
glad we're not doing that anymore. Um, Rachel, did you have any more, like, practical ways this is being used, to add?
I I would also say that there's a balance because we can type something into Chat GPT, or even if you type something into Google and there's that AI overview. How many times have, if you've ever really delved into that, that when you go to the original sources, what's in the original sources is not the actual output. So for me personally, I don't use it, which sounds counterintuitive because I write and speak on it all the time, but it takes me longer to actually generate something with AI and go back and rewrite what is inaccurate, and I get frustrated by doing that. So for me, I find it to be counterproductive, and I know a lot of other people say that as well. Also, as Dave said, what if you miss that one sentence in the email and that cost you the case, right? And then someone else finds it later, and then you're potentially up for a
Mhm.
legal malpractice suit too. And so, along those lines, the areas that we're seeing it, Jackie, in addition to the Meta case that I mentioned, formerly known as Facebook case, we're also seeing it used by experts in reports. And I know of two cases already that Dave and I were discussing while prepping. And I just happened to be on a panel last month with the judge who handled the first issue, where it was an AI expert who used AI in the drafting of the report and didn't follow step number 5 of the AI Bill of Rights. And the judge said, "Oh, the irony. Here we have an expert on AI not checking their own work." And so the expert was disqualified. And those are real world implications. We've also seen a lot of very talented lawyers sanctioned. So I think what we're seeing is it is being used, albeit I will say negligently or even recklessly, to get something on file instead of using it in a safeguarded and prudent way that aligns with our professional and fiduciary
Yeah, and I think you're
obligations.
going a little bit to where I was going next, which is what are those implications for, your our ethical obligations? What are the kind of risks involved there? I mean, you've touched on some of those already, but is there anything else you wanted to add?
I would start off by saying, though, if there was one document, and I get asked this a lot, that a lawyer should read, it should be the American Bar Association's Advisory Opinion 512, which was published on July 29th of 2024. And if you read that, it's almost like reading the model rules. You have that template for what the individual state bars are really following. So, in that particular advisory opinion, the ABA said here are really the 6 or 7 areas that AI has the biggest impact on. First, it's the attorney client privilege and protection of data. Second, it is the duty of candor to a tribunal. Third, it had to do with oversight of junior lawyers and other support staff, paralegals, and the like. Fourth, marketing those chatbots that I mentioned. Fifth, it had to do with billing. Like Dave just said, if you type something in and you're reducing time, how can you charge your client for the same amount of time? But moreover, what if it actually ends up taking you more time to correct what
Mhm.
AI generated? That's something that is really a balance. And even something so simple as an Oxford Dictionary definition, that was an extra step that Dave had to take instead of being able to say, this is a legitimate source or a legitimate definition. So, how do you balance kind of billing all of those factors? And then the last one had to do basically was with the duty to provide competent legal advice. So those areas then translate into the individual bar rules of professional responsibility. But that's where I would advise people to go to first and then frame their own policies and procedures around that, as well as understanding how the software works and if there are adequate safeguards in place.
And I think several states have also issued some opinions that largely track what the ABA's opinion put out. I am not licensed in any of the states that did it, but I know that Florida, California, New Jersey, Pennsylvania, they've all done some. And to the extent that I've taken a look at them, they look similar to the same concerns. To me, I think, you know, keeping the thread going on the trust but verify or don't trust and verify, I think a lot of the concerns that are expressed in this model opinion can be handled appropriately by just making sure you're reviewing the work and treating AI not as like your supervising partner, but as your most junior associate or legal assistant, or just as anything that requires supervision. Most of the issues, I think, can be dealt with that way. Now, if you follow the ethical obligations to double check what AI is doing, whether that ultimately winds up saving you time, which is the goal of using these new tools, that's a question that's to be determined. I think in some circumstances it definitely will, and in other circumstances it won't. But I think the one thing that cannot be addressed by the double check what AI does is the privilege and confidentiality of it.
Mhm.
And I think this to me is the real challenge. And I think that this is the next area of litigation. It is the next area of judicial opinions. It is the next area that bar associations really have to wrestle with because there are two parts to this. One part is on the attorneys. So for the attorneys listening, we know if you work at a larger or mid-sized firm, hopefully you have and somebody who's told you that you can't put client information into publicly available systems. And if you work at a small firm, hopefully you're keeping yourself apprised of the risks of doing that. And so hopefully attorneys are not putting client confidential information in there. But the question that I have in reading the ABA opinion was how confidential is confidential? How do you know when you've crossed over the line? I mean, yeah, if your client comes to you in a False Claims Act case with the document that has all of the healthcare information of all of their people who they're alleging, service X was not provided to them, but they're billing for service X, you obviously can't put that into a public facing AI system. That's very clear. But how far back along the line can you go? Like when you're searching for a bunch of CPT codes and you're trying to learn more about a certain hospital and you're trying to learn more about that hospital's billing and you're doing that all through an AI system that is trying to learn and trying to understand and how to change its responses to be more effective for you. When do you cross over the line in getting into disclosing confidential client information? And the other so that's all on us. But the other piece that we can't control is what our clients do. And so if you're a whistleblower and you're thinking, well, I'll use AI in the first instance, if you're using AI and putting your ideas in there, that may be fine, but that may wind up being discoverable. And if you have doubts, if you have concerns, if you have things that you did wrong and you're putting all these things in there and you haven't talked to an attorney about it, you may be opening yourself up to a whole can of worms. And the other thing that I think clients are doing is they're double checking their attorney's work, which is great to have somebody double checking your work. But the problem is the confidentiality of your communications with your attorney, which is one of the most important things to every attorney client relationship, potentially goes out the window if you're putting those communications into a third party source, because the question is whether you're taking reasonable steps to protect the confidentiality of that communication. So if if a whistleblower is working with their attorney, they don't feel that maybe they just want a second opinion, but they don't want to have to go and pay somebody else for that second opinion. You put it into ChatGPT, have you potentially risked the waiver of privilege, which can be really, really critical in all cases.
That's a great point, Dave. And I think de-identifying the information, how do you de-identify that? But that's talking to that software vendor to appreciate what that is. You can also run into trade secret issues if it's some type of proprietary billing software. So putting that out there could run afoul of state and federal laws as well. I've had clients send me things that were AI generated, and I was like, please don't, because it's going to take me longer to sift through all of these facts and then verify them that than if you just give me your own written summary. Another issue that I've seen come up, and Dave, what you raised is potentially downstream in terms of FRE 901 and authentication. And I've actually hypothetically had instances where people said, I deployed an AI software onto a system and there was sensitive data, but they didn't go through the regular channels with that healthcare system or with that company. And by doing that, you then have potentially a Stored Communications Act issue because it's the illegal deployment of software that then gathered all of that data. It doesn't matter if it's sensitive or not. You've now just illegally taken that information. And so, as a lawyer, you want to know if your client has any risk, and that's potentially criminal.
Yeah, so that's scary. So are there any other practical implications of how these are coming up in whistleblower cases and potentially how whistleblowers might avoid issues like that?
It's not a direct answer to your question. I will directly answer your question, but I think the indirect answer to your question is there was a really interesting case out of the Southern District of Indiana in which um, the court the court said, and I'll just read the part of the opinion really briefly. Courts have consistently held that failing to check the treatment and soundness, let alone the existence of a case warrants sanctions. And the court then cites several cases from 1998, 1988, 1986, 1984, basically saying, you have a duty to make sure that these cases actually say what you say they say, and that there isn't something else that says that case is no longer good law. And then the court went into the specific issue in that case, in that matter, which was an AI expert using AI and then not double checking, and how that creates problems. Oh, I'm sorry, I misspoke. And here's an example of just how people can misspeak. That case was about a lawyer not double checking their citations. That case was about a lawyer not double checking their citations because they had used generative AI in order to come up with citations for their brief. So I think the other ways that it's being used, I think for whistleblowers, you just really have to, or the other pitfalls or dangers or risks for whistleblowers are, you have to think about whether or not you can confidently say this is true, this is correct. Because what a whistleblower brings, in the vast majority of cases, what a whistleblower brings is firsthand knowledge that something bad is happening. It's not always the case, but that's where most whistleblowers add the most value. And, that's going to be based on what you know. And oftentimes it's because you were in the room with someone, not because you did a whole bunch of complex data analysis, but because you did the data analysis and then you talked to somebody about it and they said, I don't care, let's still build a government for this stuff, even though we're not supposed to, and we know that.
So I think that there are three tangential items. Jackie, you mentioned opening the box and seeing the dead spider. I'm sure we all remember our first week in law school where we had to go through legal research and writing. What is the first thing they tell you to do? Double check your work because you're signing off and you're attesting to that. So that hasn't changed. AI is just a tool. It doesn't mean that a lawyer's obligations no longer exist. And the case that Dave read, I think underscores that as other courts are using that same basis. If you're submitting something, it better be accurate. Anyone can have a pinpoint sign off. That's easy. You just file a notice to the court, but that's not a big deal. That's very different than fake cases or cases that no longer apply and have not applied for a very long time. So I think remembering the fundamentals of law school are very helpful. Along those same lines, I had the opportunity to ask a couple of federal judges about this issue. And I asked specifically, are you or your clerks the ones finding this, or is it opposing counsel? Because what did we learn the second week in law school? Whatever you get, right, a pleading, you're supposed to check those citations. And if they're inaccurate, you would raise them to the court. So the judge said that yes, clerks are catching it, but opposing counsel is where you're seeing those motions for sanctions and really raising that awareness to the judge because they may be getting to it before a judge or a clerk does. So that's something to be conscious of as well. Another item that relates to this landscape is we're now seeing the incorporation of local rules and judicial preferences. And the Northern District of Texas, where Judge Starr is located, he was one of the first judges to require a certification that you were certifying that you were either not using generative AI, or if you were, that you could substantiate that you verified what was there. And by that, it means doing your Westlaw, double checking that, putting that in a folder so that if you're asked, you can produce in real time that you checked it before submission. It doesn't mean going back later because they'll check for timestamps as well. And so I've also had the occasion in whistleblower cases, and this just happened a couple of months ago, where my co-counsel said our firm has implemented an attestation, so to speak, from co-counsel that you need to tell us whether or not you're using AI, because all of us who are on the pleadings could be in trouble.
Yeah.
And a recent case came out of DC, again, very reputable lawyers, but the person who drafted it, their local council submitted it without reviewing. And as a result, the wheels came off, and the judge, who's a very respected judge, just let them all have it. And the person ended up self-reporting to the disciplinary committee and the state bar where this person was licensed. So the downstream ramifications are pretty significant for not following our fundamental requirements as a lawyer.
Yeah. I don't know. It sounds like this could be a really good thing to get you kickstarted on something, but there's a whole lot of risks there. And we got to be aware of those. And so after this podcast airs, we're going to have two more that go a little bit into the nitty gritty, a little bit more on whistleblower cases. But did you have anything else to add before we sign off?
I will just say two things. I'll say if you start from the framework that AI is a tool, then you can set everything on top of that. AI is no tool is perfect, and different tools are used in different circumstances. And if you remind yourself this is a tool, then you can make sure you layer everything else on top of that. Your professional obligations, if you're an attorney, a layer on top of it. The fact that you're a client who needs legal assistance, AI is one tool for trying to figure out what your claims are. If you just remember to think of it as a tool and not the end all be all, no matter how confidently it tells you that black is white, you have to remember black is not white. And the other thing is that, I do think that there are legitimate, reasonable ways to use AI. And I think that there are, particularly with very large amounts of information, that you can't use as a person. I think it has real potential to allow force multiplication of really good people trying to do good things, and they just don't have the infinite money that sometimes powerful interests that are committing fraud have. But I would also say that there is a lot of hype right now. And there was a study done by an organization. I don't know if it's pronounced Meter or if it's METR, but Meter did a randomized control trial, and they had computer programmers divided into two groups that used AI to complete a task and groups that didn't use AI to complete a task. And they asked them before, during, and after, how much do you think AI helped you for the group that was using AI? Everybody thought that the group that used AI would do their coding faster. And after they completed the tasks, the group that used AI said, yeah, it made me go faster. But the reality is that the group that used AI was actually slower in completing their tasks than the group that did not use AI, which to one point goes to what Rachel's been talking about, which is sometimes you have to double check and it winds up being slower. That's all fine. But what the most interesting part about this to me is that people still thought they were faster, but the group was not faster. So I think it's just really important to maintain a skeptical eye, think about where it can be used. Don't necessarily say it's all bad, it's all evil. It is a tool, and it's going to become a tool that we might have to use in certain types of circumstances, but we've got to have a healthy dose of skepticism about everything from start to finish with it.
So, fun fact about me that I did not disclose at the outset is that I have served as outside counsel to an international generative AI company. And so, how different companies structure their algorithms and the safeguards that they put in place really does matter. And this company in particular, on those templates, Dave, that you mentioned, yes, they imported these different items, but they had attorneys with areas of specialization in those particular areas reviewing what those templates were and also providing pop-up boxes to say, did you consider indemnification provisions? What is your choice of law, venue, etc., that you would like in here? So that was a very different experience for me than Chat GPT, which, brings everything in. And yes, there are ways to refine how you ask for things. But I think one thing to remember is the one thing AI cannot say is no. And so it will always generate an answer. And
Yeah.
that's where I think a lot of those issues are. To Dave's point, yes, it's a tool. It's appreciating when you can use the tool and making sure that you have not only the adequate framework and use that AI blueprint as well as the ABA advisory opinion 512, but also are you meeting your legal requirements for privacy and data security? Because I think that will be a considerable issue. I think it comes down to a risk tolerance and what you're using it for and how you're using it.
Given the speed of everything that's happening, I hope this podcast is still relevant tomorrow.
I know, right? Well, thank you all so much for being with me today. We really appreciate it. We learned a lot. And thank you to Get Nick Law for sponsoring our podcast. And we'll see you next time very soon on Fraud in America.
Our annual sponsor is Getnick Law,
a boutique Manhattan law firm dedicated to fighting fraud and promoting business integrity. Learn more about the firm at www.getnicklaw.com. If you believe you've witnessed fraud against the government or on the financial markets, or want to learn more about the laws that exist to fight fraud, visit taf.org, where you can find a directory of whistleblower attorneys who work across the country. On our website, you can find information about the nation's whistleblower laws and programs and a way to donate to our organization as we continue to fight attacks on whistleblowers and these laws. Fraud in America is presented by the Anti-Fraud Coalition. Jacqueline DeMar is our host. The website for Fraud in America was designed by Wide Eye Creative. Our artwork is by PPA Agency. And our theme song is by Spatial Relations.